I'm David Rosenfeld. I'm an attorney with Weinberg, Roger, and Rosenfeld in California, and I want to talk to you about a new decision of the California Supreme Court that will be of great interest and value to construction workers. On March 25, the California Supreme Court decided a case called Huerta versus CSI Contractors. It deals with the issue of when workers are to be paid on remote construction sites. A remote construction site is where a construction worker enters the site, has to drive some distance on the site to begin work. In this case, the construction workers were working on a solar project in Monterey County. What happened was they would drive into the project, and between the entrance and where they stopped to park their cars, they had to go through a security gate where they had to stop. The security guards would look at their vehicles, sometimes search it, and they could go on. And sometimes they were held up at the security gate for a period of time. They then had to drive a further distance on the property to where they parked. And there were very strict rules about what they could do when they drove. For example, they were limited in terms of the speed. They couldn't get out of their vehicles. They couldn't play their radios loudly, largely because of concerns about endangered species. They got to the project and parked. And then there was another issue in the case which I'll address, which is their lunch break. But let's go back to the issue of whether they are to be paid during that security checkpoint. And this goes back to a case that's now almost 25 years old called Marillion versus Royal Packing, in which the California Supreme Court issued a fantastic decision that said, under California law, workers have to be paid not only when they're working, but when they're under the control of the employer, but not performing any work. In that case, agricultural workers were required to ride employer buses to the field from a gathering point. They didn't work while they were on the buses, but the California Supreme Court said they had to be paid. And the reason I'm pleased to be here talking about Huerta is that I briefed and argued Marillion almost 25 years ago. This led to this development, all this really good law in California. So let's go back to CSI and Huerta. The first issue is, did they have to be paid for that period of time when they were going through this security gate? And the court said yes. The reason is because they were under the control of the employer for at least some period of time. And the employer said, well, wait a minute. Workers often have to go through some security. They have to check in. And the court said, well, that's correct. But here it was substantially more than that. They had not only to go through the gate and show some identification, they also had to be subject to searches, and there were often long delays in going through the security. And the same was true reverse. The California Supreme Court said that under Wage Order 16 that governs construction workers, they were under the control of the employer, and they had to be paid for that period of time while they were at the security gate. And that's issue one. So that's an important issue. Time while under the control of the employer at the security gate. Issue number two was, well, what about this travel time from the security gate to where they park their cars? And the employer said, well, they're not performing any work, and they're really not under our control. And the Supreme Court agreed they weren't working and was more like commute. But even though they were under some rules that the employer imposed, such as a requirement that they not get out of the cars, not play their radios loudly, and so on, that wasn't sufficient control in the Supreme Court's view to require them to be paid. But IWC Order 16 that governs construction workers only has a unique provision that says you have to pay an employee for travel that's mandated by the employer mandated travel. So the Supreme Court said you got to pay them for that time between when they go through the security gate, which is employer required, and when they park. The third issue is a much more limited issue having to do with meal periods. Wage Order 16 allows employers and unions to negotiate alternative terms of meal periods and, in fact, to eliminate meal periods. The union that represented the workers in this case had an unusual provision that said as to meal periods, it was what we call an on-duty meal period. They had to remain at the site, and they were limited to what they could do. And the Supreme Court said that even though the union and the employer could waive the right to a meal period, what it couldn't waive was the right of these employees to receive minimum wage during that period they were required to remain at the work site. In summary, three issues. You got to pay for this time during the security gate as long as it's something more than simply going through and showing our identification. Number two, you have to pay for employer mandated travel time. And number three, you have to be paid minimum wage for any lunch period that's we're required to remain at work. Great decision. Look at it. Thank you.